incredibly frustrating when a debt collector keeps contacting you about a debt, even when they know you have a lawyer. It's not only stressful, but also likely a violation of your rights under the Fair Debt Collection Practices Act. Something I see quite often right now. Many debt collectors, even the big ones, are continually contacting folks once they know they have an attorney. And the reason they do this is because they know they're probably, especially as a junk debt buyer, they know they're not going to get any money from the attorney. And the only way to get money out of a consumer at that point is to harass them and berate them, embarrass them, and annoy them enough to where they pay them money. Generally, that's not going to happen with a lawyer. In the way, the minimum the lawyer is going to make sure the debt's valid and there's a proper chain of title, which most of the time there's not. So having an attorney in the middle can do great things. But unfortunately, sometimes they try to sidestep the rules and can contact you directly. So what does the FDCPA say about this? It says debt collectors generally cannot contact you directly once they know you have an attorney. They must communicate with your lawyer instead. And this rule exists to protect you from harassment, ensure your legal rights are respected. And I will caveat that it's supposed to be for a particular debt. They played some games with this. Sometimes you don't even know what the debt is, the account number, so you can't tell them. So we'll send a letter and then they'll still contact you because they said we didn't identify the account, even though we can't. There's some ways around that, but that's just one of the things they'll use. So you may get especially if they get a new account, sometimes Midland Funding or Portfolio, the big ones will have several accounts from somebody. And so they take the opportunity when they get a new account to contact you again. So, it's about this new account now. It's a bunch of BS. And frankly, we've deposed them and that they have effectively no intention of stopping that communication. One attorney actually told me from one debt collector that the only way they were going to stop was if, he paid them. Otherwise, they were going to keep contacting them. This is an attorney representing them on an FDA defensive case. So kind of disappointing to hear that from somebody, but that's their attitude, and that's the attitude of those kind of people. So they're going to continue to contact you. Sometimes it's an FDCPA violation, sometimes it's not. But to have a strong claim under the FDCPA, it's ideal that if you have an actual debt collector, I don't want to use the word like legitimate, or a real one, but it can't be a scammer, someone impersonating a creditor or impersonating a legitimate business. Get quite a few calls from folks who are getting scammed by people that are really smart, and they figure out you've got debts and they figure out ways to sort of convince you that they have a debt for you. And ultimately they don't. And there's usually indications of this. Some of them can speak English great. So they're clearly probably from the United States, or they're using AI or something. But they won't give you addresses. They won't send anything in the mail. And if they do, it's questionable. But that's the quick way to find out or cut out some of the scammers. If they're a scammer or they're, some kid calling from his mom's basement trying to get money out of you, it's tough to sue those people, right? First of all, you got to figure out who they are, and they never will tell you who they are. And if you do this, there's probably no money there unless you're going to put a lien on mom's basement, I guess. The debt collector knows that, or has to know that you have a lawyer. Hopefully your lawyer would have informed them. You telling them, maybe not, depending on if you gave them enough information to identify the lawyer. And then third, they should continue to contact you to collect the debt. Typically, this will be calls and letters. Quite a bit we get emails. That's been a big thing now recently where debt collectors have started emailing. One of the regulations is allowing them to do that, or at least it looks like it does. And so they're having a field day with emails, and they are continually contacting folks after they've been notified that there's an attorney involved because they don't know how to turn off the emails. It's a great idea to turn them on. They just don't know how to turn them off. So what can you do? Well, you can stop the harassment. A good FDCPA claim will force the collector to leave you alone. They generally don't want to get sued twice. Midland Funding and Portfolio are good at this. If you could have 10 accounts with them and you sue them for one, they're probably going to sell the other ones because they don't want to get sued again. They want everything. They want to be done with you. And your attorney, there's no value in them getting sued multiple times. That said, sometimes they try it. You can get some compensation. FDCPA is not going to make you rich. They set the statutory damages at $1,000 back in 1977. I think I did the math. It would be between like $5,000 and $10,000 now. So it'd be a pretty good number now, but they've never raised it. But it also covers your attorney's fees, and it covers actual damages. So your actual damages are whatever they are. I mean, whatever, a jury thinks you're getting harassed is worth. It just depends on the facts of the case. Sometimes there's actual damages in the case of medical bills, if you have to see a therapist, if it's bothering you that much. And sometimes they do. I've had clients who have ultimately attempted some very horrendous things because the debt collectors wouldn't leave her alone. So, nothing is too difficult for these people. They will do whatever it takes to get money from you. And I would encourage you not to wait to get legal help. If they keep bothering you after you've hired an attorney, don't suffer. Call your attorney, let them know what's going on. If that attorney doesn't do FDCPA work, ask them to refer it to somebody that does. Frankly, that's great. If you've got an attorney who sent them a letter of representation, told them not to contact you, but they don't do FDCPA work, because we can use that attorney as a witness. Sometimes I do the same thing. I'll handle the initial case where I do all the work, where I send letters of representation, cease and desist letters. And then when they violate it, I'll bring another attorney in to sue. That way I can be a witness, because the other side likes to play the game where they want to make the attorney a witness, because they, ethics and honor really don't sit well with them. They're going to do whatever it takes to win the case and make it difficult on everybody, not just the consumer. So that's fine. I'll bring another attorney and I'll be the witness. And we offer, and most attorneys do this, offer free consultations to see if you have a case. So if you have any questions about this or any other consumer law issue, we're happy to help. Give us a call. Cliff Carlson Law. Take care.